Thank you, my Lord. I've made it as far as my fifth chapter, which was to say something about our third overarching point, and that is that there is no basis in our submission for any challenge to the judge's findings on Ukrainian law, and that is dealt with in writing at section B3 of our skeleton argument. Now, I've already provided you with the context we say is relevant here. That was my fourth general observation. And that is that the Ukrainian law issues, which the judge had to decide in relation to the repayment defence, were themselves a subset of a much larger range of Ukrainian law issues raised by the appellants, on which the judge read and heard a huge amount of expert evidence and reviewed an enormous amount of material. And you see that from the judgment itself. The section of the judgment where the judge analyses the Ukrainian law issues extends to 55 pages and 230 paragraphs 803 to 1026. The seven findings which we've identified, which we say form the basis for his analysis of the law relevant to the repayment defence, form a subset of that. They appear under the headings Article 116-harm and Article 116-full compensation, as I showed you. And of course, that it leads to the jigsaw puzzle point, which we say is a very powerful reason on its own not to entertain invitations to second-guess specific points based on a fraction of the material that the judge had. And you heard me say, as a starting point, that it isn't appropriate, we say, for the appellants to present you with carefully picked snippets of Mr. Beketov's written or oral evidence and invite you to disagree with the judge's assessment of that, a fortiori to invite you to accept instead evidence from Mr. Alyoshin, about whom I made my submissions earlier on. That's the antithesis of the appropriate approach, we say. But there's a second point which I want to develop here, which is an equally powerful factor, and that is that one is dealing here with a code-based legal system, which is significantly different from the common law. And for that, can I ask you to turn up Perry and Mopag, which we have in the authorities bundle, beginning at page 2485. It's tab 50. I don't want to take up a huge amount of time with this, because the principles will, of course, be familiar, but this was a Cayman appeal, but it turned on issues of Israeli and Liechtenstein law, on which the trial judge had heard expert evidence. And there was a challenge to his findings on Israeli and Liechtenstein law, which failed in the Cayman Court of Appeal. And then the matter went to the Privy Council. And one of the arguments was about how the Privy Council should approach the findings that had been made in relation to Israeli law and foreign law, and the degree to which those should be regarded as akin to primary findings of fact. And obviously, you've seen the analysis, and no doubt are well familiar with it, of Lord Hodge, beginning at paragraph 8, on page 2491. I don't want to take up time with that. He obviously distinguishes between the two different ends of the spectrum. So paragraph 12 addresses the position where a foreign legal system is a common law legal system and considers the case law addresses that position. Paragraph 13 and 14 consider some of the case law on foreign law that isn't, where, for example, you have the foreign law in the form of a foreign language code. And paragraph 14 is effectively an iteration of the whole jigsaw puzzle point which I mentioned before. And then you have paragraph 15, which my own friend did mention, that there's a spectrum of circumstances with it, as it were, the common law system at one end, and at the other end, non-common law systems, different legal systems, where the judge is dependent on the expert evidence that will have, as Lord Hodge put it, close kinship with other findings of fact. Now, I just want to make this point. In this case, the board finds that the Israeli law and Liechtenstein law issues raised on the appeal were at the close kinship with primary facts end of the spectrum. And you can see that later in the judgment, so paragraph 35 to 38, in relation to Israeli law, page 2500 to 2501, and paragraphs 44 and 45 at page 2503 for Liechtenstein law. And the reason for that was that in relation to Israeli law, the position was unsettled, and so the judge had to rely on what the experts believed, applying general principles, the answer would be. And for Liechtenstein law, similarly, it depended on the appraisal of the expert evidence. But there are parallels. Of course, one needs to be careful how far one goes with that. But we say, looking at the matter as a matter of principle, and considering the spectrum identified in Perry, the Ukrainian law issues arising in this case are plainly also at the close kinship with primary fact end of the spectrum. There are really three key points in that regard. First, Ukrainian law is plainly not a common law system. It is a code-based system, which is very significantly different. Its decisions are in a foreign language, so are the other legal materials that the judge considered. Secondly, it was common law at trial that there was no single case that provided a precedent on the repayment defence issue as such. In that respect, the position we say is similar to the Israeli and Liechtenstein law issues that the Board of the Privy Council considered in Perry. The experts were seeking to opine, in this case, as they were in that case, as to what the highest court would do, how it would approach and how it would deal with the issues arising, applying general principles, in this case of the Ukrainian Civil Code and more generally Ukrainian law. And so, and this is the third point, when one considers the judge's reasoning on his findings, what one sees is that he very carefully considers the expert evidence and the primary materials, and he does that as a whole. So for example, his conclusion at paragraph 953, finding we identify as number 6, the need for looking at the issue of full compensation as a matter of substance and reality. He said he was informed by Article 316 and Article 15 of the Code, and he had heard evidence on those articles in other contexts as well. And so we say that this feature is a second equally powerful consideration. The Ukrainian legal issues involved and relevant to the repayment defence were issues under a civil law system, which is significantly different from English law. And the issues turned on the judge's appraisal of all the evidence he heard as a whole as to how general principles of Ukrainian law would be understood by a Ukrainian court, the highest Ukrainian court, grappling with the issues. We say that they are clearly at the close kinship to primary fact end of the spectrum. And for this reason, the correct approach in our submission on this appeal is that the appellants would need to show that somehow it was completely plain that the judge had made a decision in relation to this issue, accepted Ukrainian law, which no rational judge could have made. And that isn't really how they attempt to put their case, and we say it's quite impossible to put it in that way. So that's our third overarching point. Now the fourth and last overarching point that we advanced in our skeleton, section 4B4, paragraphs 39 to 48, is that there are, and were identified by the judge, two really core flaws in the way the repayment defence was advanced. And there was at trial and remains no answer to either. The first core flaw, addressed at our appeal skeleton paragraphs 40 to 44, is that the repayment defence, certainly in its pleaded version, but also in its new version, based on choice, conflated and continues to conflate three different things. Those are credit balances on the sham loan accounts, the borrower's restitutionary liabilities under Article 216 of the Ukrainian Code, and loss to the bank from the misappropriation for the purposes of Article 1166. Those are all legally and factually distinct things. And that is a point the judge made in a number of places. For example, paragraphs 1069 to 1071 of his judgment. And we say he was manifestly correct to distinguish those three things. Indeed, it seems to us at this point, that distinction is now effectively conceded. The distinction between credits in the bank's ledgers and restitutionary liabilities was conceded in our submission by paragraph 51.2 of Malone and Friends' written closing for trial, which recorded, as I've shown you, that they accepted that in a void loan case where one's dealing with restitutionary liabilities, credits didn't automatically extinguish the restitutionary liabilities. The distinction between restitutionary liabilities and loss for the purposes of Article 1166 seems to us to be effectively conceded by the acceptance, for example, in paragraph 25 of the appellant's skeleton argument, that steps such as novation or collusive settlement, which might eliminate restitutionary liability, wouldn't reduce the loss for the purposes of Article 1166. That seems to be an acceptance that is inevitable in our submission, that those two things are distinct also. And whether the loss is eliminated or reduced, therefore involves a different, in our submission, factual inquiry focused on the substance and reality. Now this, keeping these three things separate legally and factually, in our submission was always a core flaw in the repayment defence, and it unravelled as the trial went on. It was fatal to the defence for the two reasons summarised at paragraphs 43 and 44 of our skeleton argument. Those are, first, that given that these are all distinct things, simply pointing to the fact of the credits, which was the pleaded case, can never be enough to show discharge of restitutionary liabilities, still less elimination of harm on the facts. It's just a series of non sequiturs. You have to look at the circumstances of the credits and the circumstance and ask whether substance, in reality, there was a discharge of restitution liabilities, there was an elimination of harm. That's the first reason, paragraph 43. Paragraph 44, and similarly, second, given the restitutionary liabilities and loss are also distinct, even if it had been shown, which it wasn't, that there had been a discharge of restitutionary liabilities, that too wouldn't in fact be enough to show elimination of harm. Again, it's a non sequitur. You need a separate inquiry, and a factual one, and one which the judge found needed to be done as a matter of substance to determine whether harm had genuinely been eliminated. Now, in our submission, and this is essentially what the judge found, there's really no answer to this. I mean, the issues of borrower discharge and elimination of harm were always necessarily separate factual issues, and issues which the judge, directing himself to look at the substance and reality, found emphatically against the appellant. We would also add that this feature, the distinction in this case between those three things, also provides the reasons, and did at trial, that the appellant's attempts to rely on the commercially bank and euro cases are misplaced. I'll come back to that, but the basic point is that those are cases where the loss claimed was quite different. It was the impairment or non-payment of valid contractual debts. In such cases, there is coextensivity of tortious loss and debt by definition. So payment of the valid debt eliminates tortious loss or reduces it. That's simply not the case here because of this first point. So that's the first point we identify in our skeleton. I was going to move that then onto the second core flaw, which we've categorized as the fraudster's choice issue. And we dealt with that at paragraphs 45 to 48 of our appeal skeleton. And this is a flaw which is exposed once the repayment defence pivots, as it did, away from the pleaded case of automatic extinction based on credits to a case based on so-called choice, as I showed you it did during the closing. And that pivot leads to a further unanswerable difficulty. And that's the problem, in essence, which the appellants first confronted and indeed conceded at paragraph 100 of their written closing submissions for trial, and which Mr. Hard, it seems to us, accepted again orally on Tuesday. And the problem is this: any version of a choice case which is based on what happened before nationalisation, when the fraudsters were in charge of the bank, is inescapably based on the actions of the fraudsters themselves. And that is so because on the judge's unchallenged findings, they had complete control over the bank, both formally and informally, and through their multiple agents on the ground. And of course, the problem with that, which seems to be conceded, is that such a fraudster's choice could not possibly bind the bank. And that must be right. It doesn't seem to be contested. But if one asks why under Ukrainian law that's the position, it's for essentially the same reasons that the fraudulent credit values do not bind the bank. In Ukrainian legal terms, it would be an abuse of rights for fraudsters to rely on their own fraudulent conduct. And it seems to us that this was accepted by the appellants when they made the pivot to a choice-based case, see paragraph 100. The judge recorded that, see paragraph 564 of the judgment. He said that this is where he says that the appellants eschewed reliance on anything before nationalisation. He was right about that. But of course, the problem with that, so that's the second core flaw, is that that led the appellants into the world of post-nationalisation choice. And that's the case that the judge rejected as unpleaded and in any event factually unfounded. And so this second flaw leads the appellants to an impossible position. That their post-nationalisation choice case, which they were forced into to avoid this flaw, was rejected as not pleaded and not established in the facts. But they cannot now revert to some pre-nationalisation choice case, because that is hopeless. It's the case they eschewed in closing because of the fraudster's choice fallacy. And that's the second fundamental flaw that the judge and we identify with this repayment defence. There has never been any answer to it, and there is none now. That concludes my recap of our four fundamental points. What I want to do now in my 7th and 8th chapters is to take the two appeal grounds, starting because this is the logical way to do it with appeal ground 2, and explain why we say those cannot succeed. Now, to a large extent, maybe entirely, I will already have made the points that I'm going to make as I develop my overarching points. So I will be relatively brief, but I want to capture also some of the specific points my own friends made as he's gone on. So dealing first with appeal ground 2, and just to orientate you, if I may, in our skeleton, that's section C. You will, I dare say, have been struck by just how thin appeal ground 2 as developed in the appellant's written skeleton. It's dealt with in 3 pages, but the core of what's said is just 2 paragraphs. And in those paragraphs, just 2 points are made, neither of which in our submission is sustainable. So the first, which is paragraph 33 of the appellant's skeleton, was the argument that the discharge of the borrowers was not in dispute. Now that I have already covered. The judge dealt with it in detail at paragraphs 103 1035 to 1040, and he held that it was very clearly in dispute on the pleadings and in the argument before him, going through all the references. And I'm not going to go over that, but he says it's entirely right. Now, apart from that, we have only the argument articulated in the skeleton at paragraph 34, which is a challenge to the judge's rejection of the choice-based, post-nationalisation choice-based borrower-discharge case, which he, as I've shown you, rejected as unpleaded and in any event not established on the facts. And again, I've traversed this ground, but just to recap, there are two short and unanswerable points that dispose of that. First, there is just no basis which is sustainable for any challenge to the judge's rejection of the post-nationalisation choice-based case as unpleaded. I've been through all of that. It was unpleaded, he was right, and there isn't a challenge, or couldn't be a challenge to his evaluation as to how to respond to that. Second, the attempt to challenge the judge's factual finding on this, which he made on a, even if it was pleaded, I would have rejected basis, the secondary basis for rejecting it, was also doomed. And that essentially is because the appellants failed to grapple with the totality of the judge's factual analysis at paragraphs 1098 to 1123. I showed you before the overall conclusion at paragraph 1123. The reasoning and the analysis of the facts is at 1098 leading up to that paragraph. And that begins, if one picks up the judgment at paragraph page 405 of the core bundle. And as you will have seen, the judge deals with the unpleaded post-nationalisation choice in some detail, but albeit having noted that because it wasn't pleaded, that there was a lack of clarity as to what the case really was, and also a lack of evidence directly addressing important considerations, such as who at the bank could make the choice, in what way could it be made, what they would need to know for the choice to count, what exactly it was they were supposed to choose between, and so on and so forth. But notwithstanding the lack of clarity, the judge grapples with this in some detail at 405 to 412, before reaching the overall conclusion that no choice was established, even if it had been pleaded. Now, the only thing that is pointed to gainsay any of that, and it considers a number of pieces of evidence, including evidence from different witnesses, which you haven't seen anything of. The only thing is a single exchange in the cross-examination of Mr. Oleksienko. And that's mentioned in the appellant's skeleton argument at paragraph 34.2. Malone Friend developed it orally. Now, the judge dealt with that as part of all the evidence that he considered at paragraph 1112. And he sets out the core of the extract. And he records that the appellants contend, as they did in writing and orally before this court, this was relevant or informative because it showed Mr. Oleksienko accepting the bank had in its books treated the borrower's contractual debts as valid and repaid by the new loans. But he then goes on to consider whether, in light of all the evidence, that's enough to amount to a choice on behalf of the bank to allocate money or a credit balance as between one set of restitutionary liabilities and another. And he holds, considering all the evidence, that very clearly that's not. Noting, as I've mentioned, that there was a dearth of evidence as to what would be sufficient to amount to such a choice as to what knowledge a person making that choice would need to have had. Now, if you highlight paragraph, so if I could highlight paragraph 117, you can see the judge records the essence of the bank's answer on the facts had it arisen. And there are a number of points that he considers in that regard. And then you see at paragraph 118, there is a clear rejection of the case on the basis that the evidence pointed to by the defendants was not sufficient overall, even taking into account the lack of clarity as to what might count as a relevant choice. And so, in our submission, there is simply nothing close to a proper basis for challenging, bearing in mind all of the relevant principles as to how challenges to findings of primary fact are addressed, to challenging the judge's careful assessment of such evidence as he had on this unpleaded issue. And so we say the paragraph 34 challenge, that's my learned friend Skeleton, is a paradigm example of hopping onto one island, or inviting you to hop onto one island, Mr. Oxienko's cross-examination, when that's been considered, set against all of the available evidence, and the judge has made an overall assessment of the facts. And that, with respect, we say, combined with the pleading point, is the end of ground 2 of the appeal. And as we point out in our written skeleton, it also must be the end of the appeal. The judge's finding that the borrower discharge premise was neither pleaded nor made out on the facts, those are unassailable, and they alone lead to the rejection of the repayment defence. So that's my 7th penultimate chapter. The last one is to deal with appeal ground 1, which, if I am right in what I've said before, is strictly academic. But that's the ground by which the appellants seek to challenge the judge's other basis for rejecting the repayment defence. That is that there was no elimination of harm, even had the borrower discharge premise been good. Now, the judge's essential reasoning on this, and I've already covered this, is that irrespective of the status of the borrower's restitution liability, the issue of elimination of harm required a real-world factual analysis, and that when one undertook that analysis, it was abundantly clear that the steps taken by the appellants provided no genuine benefit to the bank. And our core point, the one we make in our skeleton and develop now, is that there isn't any sustainable basis for challenging either parts of that, either the finding on Ukrainian law, which is the 6th one we summarise, paragraph 953, that this is a question of fact on which the court should look at the substance, or his finding of fact that looking at it as a matter of substance, there's no genuine benefit to eliminate harm. We've analysed the points made by my learned friend in his skeleton to try to say otherwise in section D of our skeleton, being in paragraph 62. I just want to pick up some of that, if I may, to the extent that it was developed orally. Now, the first point that's been made is the assertion that the judge's reasoning isn't supported by Ukrainian law material. And the point we made in our skeleton is that, for the most part, that's an attack which doesn't actually address the judge's reasoning for rejecting the pleaded version of the repayment case, which stems from judgment paragraph 953. You don't see any, in writing or orally, explanation as to why that proposition of Ukrainian law is wrong. This morning I said that Mr. Hard hadn't gone to paragraph 953 at all. That's not quite right. He did go to it, but not to explain to you why the judge's finding on Ukrainian law there about substance and reality was right, but rather to make a much more limited point. At the start of that paragraph, there's a sentence saying that Mr. Alyoshin hadn't addressed how full compensation applied. The point that in fact the judge was making there is that Mr. Alyoshin hadn't grappled with the issue as to how one interpreted fair compensation in light of general principles of Ukrainian law, and in particular the issue of looking at matters as a matter of substance and reality. He was right about that. Nothing in Mr. Alyoshin's report grapples with the substance and reality point. But other than that, there it seems to us has been just nothing to explain to you why it is that it said that paragraph 953 it wasn't an available or even an entirely correct summary of Ukrainian law, bearing in mind the general principles that are expressly referred to in it. Instead, what we had, both in writing and orally from the appellants, is a focus almost entirely on paragraph 1081 of the judgment. Now, that in fact is not where you see the core of the analysis on the pleaded version of the repayment defence. Rather, and this is a point we explain at paragraph 66 to 70 of our appeal skeleton argument, that paragraph appears in a section of the judgment entitled Repayment Defence, Genesis of the Defendant's Case on Choice. And what the judge does in the paragraph 1081 and the paragraphs leading up to that is analyse a particular set of answers, and analyse with great care a particular set of answers given by Mr. Beketov on a hypothetical, which the judge summarises at paragraph 1076, concerned with two void loans and a hypothetical choice by the bank to treat a payment under the second as discharging restitutionary liabilities under the first. And what paragraph 1081 does is set out the judge's finding, first of all, as to what he understood Mr. Beketov's evidence to be about that, having taken great care to analyse it, and secondly, as to what, having considered that, he thought the Ukrainian law was on it. That was relevant to the unpleaded new case, but it wasn't in fact the judge's reasoning for rejecting the pleaded automatic extinction case. Taking it in relation to the unpleaded case, as we explain in paragraph 71 to 74 of our appeal skeleton, we said that was a completely fair summary of the effect of Mr. Beketov's evidence in relation to that particular hypothetical. And that is a point which is conceded by the appellants in their skeleton at paragraph 23.5. They accept that the judge's assessment of Mr. Beketov's evidence on this point is fair. And we say the judge was plainly entitled, having assessed what Mr. Beketov's evidence was on this, then to find that that did represent how Ukrainian law would apply to that hypothetical choice scenario. And I'll come on to that in a little bit more detail when I consider the attack on the judge's acceptance of Mr. Beketov's evidence on that point. For now, can I emphasise that all of that relates to the new case, and it seems to us the appellants simply fail to grapple with the judge's reasoning, both on Ukrainian law and on fact, for rejecting the pleaded case. Now, in relation to that, I mentioned this morning that I would come back to finding number 7 on coextensivity, and specifically the proposition that that finding wasn't supported by the reference to Yukub Spilka. Now, that decision we have in the supplemental bundle at tab 7, page 54. Mr. Howard went to it briefly, and I'm going to do the same. the facts, so it's supplemental bundle, page 54. The facts we've paraphrased in our skeleton argument for appeal at paragraph 76. What had happened was that the individual managers of the bank, Ukrainian bank, had caused it to use over 60% of its liquid assets to purchase a series of bonds from companies, which, as recorded in the decision, were said to show signs of fictitiousness and connection to the individuals, and which had become insolvent. That led to the bank failing and the Ukrainian Deposit Guarantee Fund stepping in. It then brought an Article 1166 claim against the managers, alleging breach of duty, harming the bank. Now, in a case where the Ukrainian Deposit Guarantee Fund steps in, there's a particular provision of Ukrainian law that, it's mentioned at paragraph 761 of the decision, makes the quantum of the amount recoverable, at least prima facie, the whole amount of the shortfall to the creditors of the bank. What happened, amongst other things, in this case was relevant to a number of points, but was that there was an argument in the case that the Deposit Guarantee Fund should not recover that loss, or should recover a reduced amount, because it had failed to pursue the bond sellers for a declaration that the bond transactions were void and for restitution of the money. You see that at paragraph 769, page 73. And that argument was rejected, and the relevant paragraphs for this purpose are 771 and 772. And what the Grand Chamber says, those paragraphs, in essence, is there was no need, it wasn't appropriate or reasonably necessary for the Deposit Guarantee Fund to take steps against the bond sellers, because in all the circumstances, the application of the consequences of voidness, restitution, would not, as a matter of fact, significantly affect the total value of the liquidation estate. Because, in a nutshell, the bond sellers were insolvent or impecunious. And that's the effect of 771, 772 on page 73. Now, we say one can glean two things from that. First, the Grand Chamber treats the Article 116 tortious claim and the possible claim for restitution consequent upon voidness as different and distinct claims. And secondly, it plainly considers the relevance of the latter as being factual. The issue it was interested in, and the issue relevant to what we would think of as mitigation, is would pursuing such a claim as a matter of fact and substance reduce the tortious loss because it would lead to a recovery. It found it wouldn't, so there was no failure to mitigate. And the judge was completely right in our submission to have regard to that case in support of the proposition that in the event of voidness, a tortious loss and a restitutionary liability are not legally or factually coextensive. It did indeed provide additional support for the finding we summarise as his seventh finding. So that's Ukop-Spilka. Can I turn next to the second point made under Appeal Grant 1, which is about Commercially Bank and Eurov. We've dealt with this in section D2 of our skeleton arguments, paragraphs 78 to 87. I'm not going to repeat that, but I do want to emphasise three key points. The first is that it was most certainly not agreed between the experts that these cases reflected the Ukrainian law relevant to the repayment defence. We set out the true position in that regard, paragraph 79 of our skeleton argument. In the first round of experts' reports, neither expert referred to Yurov or Kolomoisky Bank in connection with the repayment defence. Mr. Alyoshin made no reference to either case on any point. Mr. Beketov did refer to Yurov, but on the other quantum defence, use of funds, I think it was shown in the passage, but the reason he referred to it, having said what he thought Ukrainian law was to note that, the articulation of effectively the same general principle in Yurov about use of funds accorded with how he said Ukrainian law operated. And so he referred to it in that context. In the joint report, it was then recorded that the position on use of funds was agreed, but the joint report, of course, recorded the fundamental disagreement on the repayment defence, and in that regard, I think you were shown this, it made no reference to Yurov or Kolomoisky Bank. It's paragraph 11 of the joint report. Then after the joint report, Mr. Alyoshin introduced an argument on the repayment defence based on Yurov for the first time. That's the sequence. So it's quite wrong to say that it was agreed by the experts that Yurov or Kolomoisky Bank somehow represented Ukrainian law on the issue relevant, issue or issues relevant to the repayment. So that's the first point. The second point is that those cases are not authority, even under English law, as to the points at issue under the repayment defence, which are whether the credits to the sham loan accounts discharged the borrowers, and if so, whether that eliminated the loss being claimed for in tort. Not only were they not claims for loss of money, there was no repayment defence in either case. The defences that were raised were concerned with use of funds. So that's the second point. The third point then is, and again, we've developed this in detail in our skeletons, that when one considers what those cases had to say in that very different context, considering the different use of funds defence about extinction of losses, it's perfectly clear that they were concerned with a different fact pattern. And they don't, even as obiter dicta, have any application to the facts of this case on that issue at all. The core point, and again, we've developed this in the skeleton, is that those cases both concern valid contractual debts or obligations, and the loss claimed and at issue in both cases was a loss defined by reference to that valid contractual debt. The claim in each case was that the victim had been induced to part with money in exchange for valid but impaired contractual obligations. The transaction was a contract. The contractual obligations were to pay the money back, and the claim in each case was for the unrepaid shortfall. The amount hadn't been paid back under the contract. It follows necessarily in such cases that repayment of the valid contractual debt reduces the shortfall. The shortfall is the loss, and hence it reduces the loss. Now, I'll add to that, in neither of those cases was there any dispute but whether and to what extent the contractual debt had been validly repaid through the provisions of genuine benefit. Not only was there no repayment defence, but to the extent that repayment of the contractual debts, the valid contractual debts, had happened, it was agreed. And there was no claim for the repaid elements of the contractual debt. Now, that's all explained by reference to the relevant paragraphs in those cases, paragraphs 80 to 85 of our skeleton argument. I will just add that there was a suggestion by my own friend that somehow Yurov should be regarded as a void loan case. It was day one, page 45, lines 23 to 46. It isn't. It's clearly not such a case from the very outset. See paragraph 4. Can I also add to that, and I won't turn it up unless you wish me to, paragraph 1180, which makes it very clear that that was not the nature of the claim in Yurov, and that it was concerned with loss comprising shortfall in valid contractual debt. Now, this point was a point that we made very clear, this distinction and the irrelevance of Kolomoisky Bank and Euro on this issue, all the way through the trial, from our written and oral opening through our written and oral closings. And the judge accepted that, and he was right to do so. Now, he confirms that in his consequential judgment, at paragraph 132, the reference is core bundle, page 705. Rundfeld made a point that he doesn't say it in terms in the main judgment. As far as it goes, that is right. But, of course, you are well familiar with the fact that the judge it doesn't have to set out every single last piece of analysis that forms the basis of his judgment. And in fact, the assumption is that he has considered points, unless for some reason it's very clear that he hasn't. This was a point which was argued over and over again. He plainly did regard Euro and Kolomoisky Bank is not relevant to the analysis. He was right about that. He confirms that he did that at paragraph 132 of his consequential judgment. So that was all I was proposing to say about those cases. I was going to then consider the attack made in relation to Mr. Beketov, which you heard quite a lot about orally. And the essence of it is that although it's accepted that paragraph 1081 is an accurate summary of what Mr. Beketov had to say about that hypothetical choice scenario, it is, the judge was not entitled to accept Mr. Beketov's evidence as representing Ukrainian law on the point. And there are three introductory points to make here. I've already made all three, but I'm going to recap them as they are specifically relevant to this. The first is to remind you that in the first defendant's written closing submissions at trial, the appellant jettisoned Mr. Alyoshin and asked the judge to determine the repayment defence reorientated so as to be based on choice, based on Mr. Beketov's evidence. They can hardly complain when he then did that. The second is that the appellants do not now dispute that the judge has correctly summarised what Mr. Beketov was saying in his evidence. See paragraph 23.5, core bundle, page 93. And that includes the summary of his evidence in paragraph 1081. And the third is the point made in amongst other places by Lord Hodge in Perry at paragraph 16. And that is the whole jigsaw puzzle point. The fact is that this judge had heard Mr. Beketov and Mr. Alyoshin give differing opinions on multiple issues and had reached the overall conclusion that Mr. Beketov was the credible, objective, expert witness before him. That was based on the whole of the jigsaw puzzle comprising the expert evidence. More than 300 pages of written evidence for each witness, a week of cross-examination, hundreds of exhibits. And I've already mentioned the damning conclusions he reached in relation to Mr. Alyoshin. He reached the reverse conclusion in relation to Mr. Beketov, but both by accepting his evidence on the other issues of dispute, but more generally, see judgment paragraph 808 at page 334, where his overall assessment, this is the equivalent of the paragraphs I took you to in relation to Mr. Alyoshin, was that Mr. Beketov was an honest, independent and diligent witness who did his best to assist the court. Now, it's also important that the judge recognised in the same paragraph that there were aspects of Mr. Beketov's evidence on the detail which were not as well expressed as others, on occasions where, as the judge put it, he lost the thread of questions. That, frankly, is unsurprising for a witness giving evidence over several days on complicated legal issues in his second language. What it meant, and this is what the judge says in that paragraph, is that the judge needed, in relation to those matters where there was that element, to consider very carefully what the substance of his evidence was. And that is exactly what he did. He considered with very great care, from the perspective of familiarity with the totality of his evidence, and having been able to observe him, he considered what the substance of his evidence was. Now, in that context, in our submission, it is a wholly impermissible exercise to do what the appellants have sought to do in this appeal, and present to you fragments of Mr. Beketoff's evidence and invite you to disagree with the judge's considered assessment as to whether that evidence represents Ukrainian law. That is, again, island hopping, to use once again the well-known phrase. So those are the general points. If I move to the specific criticisms, which were made in writing at the appellant's skeleton argument, paragraphs 90 to 95, and developed at some length orally, they really come to two things. First, there is the contention that what Mr. Beketoff had to say about how Ukrainian law would respond in this case to the hypothetical choice case is now said to be ipse dixit. No, that's in our submission baseless. It was common ground, and the judge recorded this, that there was no case directly on the factual circumstances that presented themselves in this case. So the task for the Ukrainian lawyers was to provide their expert view on the principles, including the general principles, and as to how the apex Ukrainian court would resolve the issue applying those principles. And Mr. Beketoff explained very clearly his view that Ukrainian court would be guided in particular by Articles 3.1.6, justice, fairness and reasonableness, and Article 15, respect for the victim's rights. And we've included in the supplemental bundle extracts where he explained those concepts in writing. Those are collected in paragraphs 75 and 76 of our appeal bundle, and they appear in the supplemental bundle at tab 1, beginning at page 5, running through to page 13, and tab 5, beginning at page 29, running through to page 42.
Is your basic point here, it's really not valid or acceptable to stigmatize as an ipse dixit when your expert witness is doing precisely what he's supposed to do, which is offer an opinion in a situation where there's no existing authority in Ukrainian law one way or the other.
Precisely.
And it's that very expertise which he has, which gives it evidential value for the court.
That's exactly it. This is not unreasoned. This is not a, I say it's this, so it's this. Yeah. And so it's exactly that. As to the particular criticism of the section of Mr. Beketoff's oral evidence in which the particular hypothetical choice point was put, starting with an example involving, I think, Mr. Howard and I engaging in a theft, you had a huge amount of focus on that. But what it boils down to is Mr. Beketoff initially gave one answer, which in isolation appeared to accept that the loss might reduce in that hypothesis, and then later explained that he hadn't appreciated that the questions, this was on the second day, day 28, were being put on the basis that the repayment was using the victim's own resources, and that his view for repayments comprising credit source from the victim's own resources was that there wouldn't be a reduction. And the judge considered that very, very carefully indeed in the judgment. See paragraphs 1062 to 1066. And indeed he noted that he would consider it carefully at the time. It's in the transcript. And his conclusion was that this was an instance where Mr. Beketoff, as he himself explained, had not fully followed the questioning initially, or at least hadn't appreciated that it was supposed to be the case that the premise was that the repayment was using the victim's own resources, or more accurately, that premise had been carried over from the previous day. Because, in fact, if one gets into the weeds, the central criticism here is unfair. If you look at the transcript, the questions that begin on day 28 at page 114, it's in internal page 2295, relating to the example involving me, at no point in that line of questioning does Mr. Howard explain that the repayment he's talking about came from the victim's own resources. That was all said the previous day. And so when the witness pointed out to Mr. Howard that he hadn't understood that, frankly, if one gets into the weeds, that's an understandable position. But our bigger point, the one that really matters, is that axiomatically, this is an assessment for the trial judge to make, having considered the entirety of Mr. Beketov's very extensive written and oral evidence. And that is what he did. And having made that assessment and set it out in detail and done it with great care on this point, there is no proper basis for the appellants to say to this court, look at these bits of Mr. Beketov evidence that we've picked out and put in the supplemental bundle, and on that basis disagree with the trial judge's assessment that that's credible evidence. That is the antithesis of the proper approach on an appeal in relation to matters of Ukraine, of a foreign legal system that is not a common law system, as articulated by Lord Hodge in Paris. So that's what we have to say about Mr. Beketov. The next point is Mr. Alyoshin, and I've largely covered this as part of the fourth observation that I started with this morning. The same fundamental point applies here. The trial judge was entitled to and did base his assessment of Mr. Alyoshin's evidence, the whole of his evidence, including the whole of his written materials and the whole of his cross-examination. And having done that, the judge made the polar opposite assessment in relation to Mr. Alyoshin as he did to Mr. Beketov, both on independence and on general credibility, which was significantly compromised. And we've summarised that. I've already been through it to some extent.
Yes, well, we've seen that. The submission that's made here is that the passages in question it is submitted were not challenged.
And that specific point is wrong. It was not a point made at trial, and it's wrong. We've dealt with that in paragraphs 97 to 98 of our skeleton. And the core point here is that we did challenge that evidence, including in cross-examination, where the core proposition that he was wrong in relation to how he said Ukrainian law operated here, because it was a matter both on discharge and elimination of harm as of fact to be judged looking at the reality. That was put to him in the extracts you have. My friend didn't go to this. In supplemental bundle, tab 12, we've got an extract at 120 to 131. And if you read all the way through that, I wasn't proposing to go through it because my own friend didn't, you can see that I did put the fact, which is the core fact, that these were issues that needed to be addressed as a matter of fact, both in relation to discharge and elimination of harm in that passage. What happens, when one reads that passage through to the end, is that when we, in order to explore it further, embarked on an attempt to go through hypotheticals in order to more rigorously test what he was saying, he did what the judge found he did at various points, which was to become highly evasive, and he purported not to follow the development of the hypotheticals that I was seeking to put with him. And if one reads that passage through to the end, it's clear that by the end of the day, the judge, frankly, was fed up with that and told us to move on, which we duly did the next day. And that is entirely understandable given the position that had been reached by that point, because you don't have the whole day's cross-examination, but you do have the judge's findings that followed from what had happened earlier in the day, and what continued to happen the next day. And that included all of the adverse findings in relation to suppression of material and so forth, and evasion. And so, first of all, we did put the core point to him. And secondly, and the judge gave a clear indication that was sufficient. And so we moved on. So there is no basis for that submission. It isn't a submission at all that was made to the trial judge. I've shown you the way that the point in relation to Mr. Alyoshin was put to the trial judge. It was said to him, he's irrelevant. We don't even invite you to make findings as to whether he's credible or not. Well, that's our, and we've captured those points and made some additional points in our skeleton at paragraphs 97 to 98. Can I lastly pick up on some other miscellaneous points made primarily orally? One point is the suggestion that the judge's finding at 1081 in relation to the hypothetical choice scenario being addressed in that paragraph, and accepting Mr. Beketov's evidence as representing Ukrainian law, was, as he put it, inherently implausible because it involved a distinction between valid and void loans. Now, the difficulty with that, amongst other things, is that the appellants themselves accepted and argued for that very distinction in their closings. And we've given the references to that, but most obviously it's paragraph 51 of the written closings. And indeed, my learned friend, in his oral submissions to you, accepted that there was a conceptual distinction. He was dealing with English law, making this submission, but it's day 1, page 81, 17 to 25. Date, wrong reference. Day 1, page 132, lines 10 to 19. And in the passage reads, the point I'm making is this, my lord, if I can just contrast the two situations. In a contractual setting, the debtor can force the bank's hand, because he says this is repayment of that loan pursuant to my contractual obligation. In a restitutionary sense, the person handing over the money can't force the bank's hand, because if there's more than one liability, the bank can choose which liability it's going to treat as a payment in respect of. So in that sense, it has a choice. It's not automatic in that sense. By tendering the money, it automatically calls the restitution liability to terminate. So the suggestion that 1081 is to be criticised for making a distinction is unsustainable, given that that's a distinction that the appellants themselves, both before the trial judge and before you, have argued for. And next miscellaneous point, I think I probably covered, that was ignoring Commercially Bank and Eurov. That's not a fair point for the reasons I've given. There were criticisms to the effect that the judge was confused as to what the appellant's case really was at various points. All I want to say about that is we said the very opposite is true. He was meticulous about tracking how the case was being put, even when it might have, at some points, become difficult or obscure. He worked through it with great rigour, including tracking exactly how the case shifted. Just to pick up a detailed point under the same head, the idea that the judge misunderstood the submissions being made to him. My learned friend said orally that in the paragraphs 1065 to 1070 of the judgment, the judge was wrong to suggest that the repayment defence depended on a submission about coextensivity between the liability of the tortfeasor and the borrower. He wasn't wrong that that was the case being put to him, or being put, at least in opening, and we've given a reference to that. It's oral opening on day 6 of the trial, supplemental bundle, page 106, internal page 50, line 11 to page 51, line 10, and the passage, and I think I showed you it briefly this morning, reads, "My Lord, leaving that complication to one side, we say it's actually obvious as a matter of analysis that the liability of the borrower and of the defendants on the facts alleged is coextensive. The liability of the borrower, whether in contract or restitution, to repay the amount of the drawdown, loss caused by the alleged conduct of the defendants was causing the loan to be drawn down, procuring it. So the liability of the borrower and the loss to the bank are two sides of the same coin." So it was put, and the judge was right to record it being put in opening as based on coextensivity. Now, of course, that was then abandoned in the case of the void loan by paragraph 51(2). And so the submission made by my learned friend on Tuesday, page 121, lines 20 to 25, the judge had misunderstood the defence and that there was never a coextensivity argument. That isn't right. The judge correctly understood it. It changed, but that wasn't how it was put originally. And then I think the last point is just to pick up some of the things my learned friend said this morning in relation to asset transfer. So 3 quick points. My learned friend took you to footnote 47 of, someone will tell me which of Mr. Beketoff's reports it was.
I think it was the 8th.
The 8th, yes, suggesting that the bank had never challenged, I think the thrust was never challenged valuation of the assets. The point that's mentioned there is in relation to allocation. So as I'll show you, the bank always has challenged the values. It's never accepted those. But the point that's picked up, and it's mentioned also in the forensic accounting reports, is that separately from the issue of what the true values of all these assets were, there was an issue as to how they should be allocated as between the harm, the tortious loss, and other matters. And the footnote relates to that, just to allocation. It doesn't say anything about valuation. The second point, which is along the similar lines, it was suggested that the bank had accepted credit values by its conduct after nationalisation. It did no such thing. The judge, in fact, considers this at another part of his judgment. The most relevant paragraph is paragraph 532. And I won't turn it up unless you wish me to, but there the judge explains that after nationalisation, the bank restated and wrote down the value of the assets on its books because they were overvalued. And then the third thing, it was suggested that Mr. Beketoff had given evidence as to how a choice might be made in relation to asset transfers to accept the deliberately false values at their full value. He didn't. You were taken to a passage of his cross-examination. I won't go back to it, but the questions he were asked were on the premise that there had been a choice. At no point was Mr. Beketoff asked to opine on what he thought would be a valid choice. What sort of conduct would amount to a valid choice, who at the bank would be authorised to do it, what knowledge they would need to have, and so forth. He was never asked anything about that. The questions he were asked were always on the premise that there was a choice. So those are the miscellaneous points I wanted to address in relation to appeal ground 1. To draw the threads together, if I may, in our submission, there is nothing under appeal ground 1 which provides any proper basis for for a challenge to the judge's assessment, either that the correct approach was to consider whether there was a genuine benefit as a matter of substance and reality, or for his assessment that the steps taken by the appellants to cover up the misappropriation through the intermediate drawdowns, the new loans, and the asset transfers provided no such real benefit to the bank, save only for the true value of the assets, and that there was accordingly no extinction of harm for that reason. In our submission, Appeal Grant 1 should be dismissed for that reason. Well, those are my submissions. For all those reasons, subject to anything else you would like me to address, we invite the court to dismiss both grounds of appeal. The judge's rejection of the repayment defence in our submission, which was one which followed inevitably from his finding that the basis advanced to him in the end for it wasn't pleaded, and from his findings that Ukrainian law required him to consider the substance of the position, and from his findings of fact rejecting both the limbs of the defence, the borrower discharge premise and elimination of harm. In our submission, those are all unassailable conclusions, and neither ground of appeal can stand in light of them. Those are my submissions.
Thank you very much. Mr. Howard, will you reply?
My Lords, the first point I'd like to make in reply is this. Your Lordships have been addressed by Mr. Hunter on what he says the judge found on Ukrainian law. The one thing he hasn't mentioned, which is actually significant, is what was the Ukrainian legal position where somebody in control of a bank, as in this case, wrongfully causes a loan to be taken by a company he controls, but the loan is a valid loan because it is within the limits and so on and authority, but he is acting wrongfully. He then subsequently takes out another loan, or he misappropriates money from the bank, and he uses the misappropriated money to repay the loan. Now, Mr. Beketov's evidence was absolutely clear and unequivocal about that situation. In that situation, the loan, because it was a valid loan, was repaid, and even though it was repaid out of the bank's resources, that would extinguish any claim in tort for having procured the first loan. Now, in my submission, that when one comes to consider both the judge's findings on Ukrainian law generally and applying it to the facts of the case, that is particularly important. So in other words, in that particular situation that I've just outlined, the suggestion that you can wave your arm around and say, well, is this fair, just and reasonable in Ukraine? Or say, is that full compensation? None of that would actually work. Mr. Beketov he originally was suggesting that, but when he was cross-examined, he conceded that in that situation, both there would be repayment and there would be extinguishment of the tort. So that's one thing I wanted to just get everybody to think about at the outset. Now, the second point I need to address, or want to address at the outset, is the issue of what actually was in play. And my learned friend, quite understandably, has sought to ride with the judge, saying that we were running a new case at in closing, and the judge was right not to allow that. Now, in our submission, as this is all being completely overblown, both by the judge and by my learned friend. Now, a lot of reliance has been placed on what's the reference? Yeah, in the supplementary. Yeah, a lot of reliance has been placed upon what we said in closing at page supplementary bundle 148, and to suggest that in our written closing we were saying something different to what we had been saying before. Now, if you actually read 51 and 52, what you'll see is that, yes, we recognise there was a distinction between valid and void loans. I'll come back to 51 in a moment. But 52 explained, crucially, however, void loans are no different from valid loans in the sense that if the loan monies are repaid and liability of the borrower is discharged, then any tortious loss is also extinguished. So our case had always been that the loans, whether they were valid or void, had been repaid, and that the effect of repayment was to extinguish the tortious loss. Now, the only point that we were making, or the point we were making at 51, the distinction between a valid loan and a void loan, and is a point I made to you this morning. In one case, if the relevant loan is valid, then when the borrower turns up and says, "Here is my money for the relevant loan," that automatically means he's repaid it. Whereas in restitution, if there was more than one restitutionary obligation owed, the bank could choose which one it wanted to treat as being repaid. Now, you have to come back to the facts of our case. What does that mean on the facts of our case? Where the loans were void, or the relevant loans were void, as the judge has now found, the impact of that was that, let me start again. The relevant loans, in terms of what are called cash repayments, were being paid out of what have been called intermediary loans or the new loans. Now, when the money goes from, let's take the case of a new borrower, the money went from the bank to the new borrower, to the relevant borrower, to the bank. Now, the bank could, when receiving that money, have said, "No, I'm not treating this as a repayment of the relevant loan. I'm going to treat it as a repayment of the new loan." It could, in theory, have done that. But as a matter of fact, the bank has not done that. As a matter of fact, and this is actually not in dispute, and Mr. Hunter has nothing to say about this, all of the relevant loans, as far as the bank is concerned, have been repaid. That's what was recorded at the time when payments were made, and that remains the position today. And that's why Mr. Hunter doesn't say anything about it. The bank, what Mr. Oleksenko said in evidence was, of course, all of the relevant borrowers have their liabilities have been extinguished. That is the bank's position. And so when you come to the debate about there are two debates on the pleadings that the court needs to recognise. The one debate was, had the bank accepted on the pleadings that the payments had been made and that the the liabilities of the borrowers had been discharged. And the second was it open to us to run the case in what has been called the choice case? Now, on the first point, had the bank in its pleadings accepted that payments had been made and that they had been credited in the way that we said? Well, there are two things to say about that. One is it's a submission I've already made. But when the bank talked about purported repayments, that was because it was talking about payments in respect of loans which it said were void, but it wasn't disputing the fact of the payments, because it couldn't. Those payments had been made. Yeah, they accepted they've been made. They accept that these payments are recorded as having been made, and the dispute, and this is if you track through the expert evidence and what Mr. Beketov was saying, was that their dispute was that these payments weren't effective to extinguish or reduce the loss, and that's, as it were, the Ukrainian legal issue that we had to deal with. But in our submission, actually on the pleadings, when properly analysed, the judge was wrong to say that the bank's position was that there hadn't been payments, because there plainly had, and that wasn't what the bank was saying, or that the payments hadn't been treated as repaying or discharging the debts. Their point was a different one. So that's one pleading point. Now, the other pleading point is, and one has to understand how the point on what has been called choice arose and how that has now been elevated into a bigger point than it actually was. And I explained this, in fact, to the judge in closing. Our position was that on the pleadings, there actually wasn't any dispute that payments had been made. But in any event, insofar as that was put in issue, the materials showed that the payments had been made. And just interposing for a moment, it was common ground, and I think this is a point that we've discussed on a couple of times. It comes out of the discussion that Lord Justice Nugee had with my learned friend. When, as a matter of Ukrainian law, and it's a point the judge refers to, when a credit is made to an account, that is treated as property of the account holder. Now, the important thing is that is also the case where that is made pursuant to a void loan. So that where the money, where there was a void loan, but money was paid to the account of, say, a new borrower, the money in the new borrower's account is then for him to deal with as he pleases. And the only way the bank can stop it is if it sued him and got some sort of order to stop it. But the bank otherwise can't do anything about it. And the new borrowers in this case, and the intermediate borrowers, received real money, and that money was then paid was paid by the intermediate borrowers to the relevant borrowers, and by the new borrowers to the relevant borrowers. In other words, this was real payment of money. Now, our case had always been and remains that all of the relevant loans had been repaid. Now, the development at the trial in relation to this was not that we were saying anything different had happened in terms of payment. We were relying on exactly the same payments. But what we recognized at the trial is the point that Mr. Hunter has made in his skeleton argument and made orally, which is that payments which were credited and treated by the bank when the defendants were in charge, it might be said against us, well, the bank isn't bound by that because the fraudsters, as it were in charge. But, and therefore, what we said was we rely on the payments having been made, but we say that not only were the credits made at the time they were, but also at all times subsequent, including after nationalisation, when everybody knew the full facts, the payments have continued to be recognised and you have continued to treat the relevant borrowers as discharged. And so we suggest that the judge was wrong to say that this was some major development in our case and that it required an amendment to our case. Our case was and is that the relevant loans had been repaid. We relied on the payments that were made via the intermediate borrowers and the new borrowers and the assets that were transferred. And we were simply anticipating an answer that would come from the bank, which was to say, well, the credits that were accepted was all being done when the defendants were in charge. And so we dealt with that by saying, well, the fact is the new management also accepted the position. And my learned friend said at the very end of his submissions just now, rather interestingly, he said in relation to the assets, he said that the true position is that after nationalisation, he said the judge recognised this at paragraph 532, the bank restated the value of its assets. And so he said, look, that shows that the bank has been treating this differently after nationalisation. That actually gives the lie to the whole point. What happened with the assets is the assets come onto the books of the bank, and the bank has then treated has credited in the loan accounts what they were prepared at that stage to treat as the value of the assets. Of course, that meant the bank was holding the assets. The bank has chosen to restate the value of the assets, but it hasn't altered the position on the relevant loans. Its position remains to this day that the relevant loans have been repaid. And so, my lords, we submit it's a very important starting point for this, that all the relevant loans have in fact been repaid. They've certainly been treated as being repaid, but it is in fact they have been repaid. And the fact that the repayment may, in the case of the cash transfers, originate with, if you like, a different fraud on the bank. The fact is that the bank can sue on that different fraud, but the people who were responsible for the different fraud have used the money which under Ukrainian law became theirs to repay the earlier restitutionary obligations and so extinguish the loss. Yeah, and what I'm saying to your lordships now, because it's being said, well, that we are shifting our position, is precisely what we submitted in closing to the judge on day 39. Yeah, and we can supply the transcript if in due course. Now, just then picking up some of the points in my learned friend's submissions. Now, he started by saying that it was wrong for us and for me to say that they had arbitrarily chosen to sue on the relevant drawdowns, and that was all historic, and those were the real cause of their loss. But there are two things about that. First, the loss, according to them, that they had suffered by the time of nationalisation from the defendants' conduct, or if you like, misconduct, was $5.5 billion. So it's a sum of well over double the amount. So one firstly is in a situation where it was a very odd situation to sue, as it were, on a part of the conduct. But secondly, it's all very well saying the relevant drawdowns were what my friend described as the key to money going out of Ukraine. But ultimately, the loss that they suffered and the loss that they were left with in 2016 was the loss caused by the new loans. And the new loans were used in part to repay the relevant drawdowns as well as other debts. And so what the bank was ultimately left with at that stage, and they could have sued on, and one would have expected them to sue on, is either the new loans or the entire course of conduct. But the difficulty for them remains that the 270 drawdowns have been repaid. Now, the suggestions, for instance, a point my learned friend likes to say, he said on a number of occasions, that the new loans and the intermediary loans were, he says, an artifice to cover up the misappropriation. Now, what you have to do is one has to move away from sort of some general description and actually work out, well, what has actually happened. And once you work out that under the new loans, what actually happened was money, large amounts of money, actually do move to the new borrowers, becomes their money which they use to repay various indebtedness, then to describe that as it were, as if it were just paper transactions is simply false. They are real transactions with real effect. Now, when going back to what my learned friend was saying about what he calls the borrowed discharge premise, and his suggestion that our case has changed, our case remains, and always has remained, that the relevant drawdowns were repaid, and they were repaid both by monies which were sent, which originated with the intermediate borrowers and the new borrowers, and by the asset transfers. And none of that changed. And the suggestion that there was, well, sorry, I think I've made that point. And if we go to the judgment at 1086 first. You can see here where the judge was accepting the bank's argument, and where the judge says in the middle of the paragraph, it said, that's the bank, as a matter of fact, it hasn't received anything of real value which would make it whole. It still has a worthless, fraudulent loan on its books. That really encompasses the major problem with my learned friend's analysis and that of the judge. That what that is, the mistake that is making is to treat the fact that if you take the new loan, the bank has a worthless, fraudulent loan on its books, as if that is the same loss as the loss on the relevant loan. It's simply a different loss which gives rise to a different claim. Yeah, I mean, and the suggestion that there hasn't been real benefit to the bank has received real benefit because it has received, in the repayment, it has received a payment which has eliminated repaid the restitutionary liability on the relevant loan. It's just that it also then has a different claim against the parties responsible for the new loan. Now, and paragraph 1090 of the judgment, which my learned friend said, well, that is referring to paragraph 100 of our closing. And it said, here the judge says, Kolomoisky went on to make it clear he didn't rely for the purposes of establishing the bank's choice as a matter of fact on the initial credit of the relevant borrower's account with repayment. I mean, what is being compressed within that paragraph is that we do rely, and we told the judge we relied on the fact of payment having been made and the payment having been credited to the borrower's account. But the point that we were making on choice and why is that we recognized that we couldn't simply rely on what the bank had done while they were in charge, and we relied on what had happened subsequently to affirm that, or if you like, for the bank to choose that. But the bank, post-nationalisation, has...
I'm interested in your choice of the word affirm.
Yes.
Because one might think that if a case of affirmation is being run, that is a case that would need to be pleaded.
Well, the point, yes, my lord, but my response to that is, and the way the pleading case emerged was the bank didn't ever plead that, which is what you would have expected to happen. If we take it in stages, Mr. Kolomoisky, the defendants, had pleaded that each of the relevant drawdowns had been repaid. Either by what were called cash repayments or by assets. Now, the bank didn't at any stage plead in answer to that, well, yes, we did get the money, but we're not, and we have credited it in the way you say, but we're not bound by that, and we've undone those transactions because that was all done by you as the fraudsters. The bank didn't plead that. Now, if they had pleaded that, then we would have answered that in a pleading to say, well, even if you're right, or if they simply pleaded that was all done by you as fraudsters, we would have pleaded back, well, you haven't changed the position. In other words, it would come as a plea by us in answer to them, saying we're not bound by what was done when you were there.
I understand that submission, but on that submission, you had no business raising the argument in the first place, because you were, on that theory of the case, you're meeting an argument that the bank has never advanced.
Well, the thing is, your Lordship, I agree with you, is right, but we recognised, sometimes in large trials, you recognise what issue is likely to come forward. And when I was cross-examining Mr. Beketov, because it's important to understand the genesis of this. And if you reread the cross-examination that I showed you with Mr. Beketov, when I was asking him about this, what emerged was, well, of course, he said for a restitutionary, a payment in respect of a restitutionary liability, it would depend upon whether a choice had been made. And the point that emerged was, well, if you're looking at choice, you'd then need to consider whether or not the fraudsters could make a choice, or whether you'd have to see whether the choice was made at a later stage. But we were just anticipating, in the light of that the bank would say, when we said we rely on the fact that the bank, let's say in the middle of 2015, treated a payment via an intermediary loan as a repayment, that it would be said, oh, well, that was when you were in charge. And so we were simply saying, well, it doesn't matter, because the fact is you, the bank now, since end of 2016, having been nationalised, you've continued to go along with this. And indeed, not only, we said that was sufficient for our purposes, but they went further. But your Lordship is right. We could have, on the pleadings, just said, well, there isn't actually any need for us to raise this at all. But my simple point is that this was a responsive point to what we anticipated the bank was going to say. So, and our submission is that in the light of where matters developed in cross-examination, in relation to the question of whether or not the restitutionary obligations or liabilities were discharged by the payments and the provision and the asset transfers and the subsequent crediting of the accounts, it was simply a question of fact as to what had happened, and there wasn't actually any real room for a dispute of fact. Now, your Lordships have been addressed both by my learned friend and me on what is the correct approach to the expert evidence in a case of this sort. And we both rely on the decision of the Privy Council, I think, in the Perry case. And I have been entirely open about the position that I accept that we're dealing with foreign law from a civil law country, and so it's generally at the one end of the spectrum. But when you look at what it is we were dealing with here, the relevant part of Mr. Beketov's evidence on this point was actually very confined. It's all very well saying the judge had to deal with a lot of other points, and there was a lot of other expert evidence. What's actually important to understand about this case is the repayment defense was front and central. It had been the basis that we had challenged jurisdiction, or a very similar basis, and been to the Court of Appeal. And we had always been saying that whatever the rights and wrongs of everything else, these relevant drawdowns had been repaid. So it was something actually very central for the judge to deal with. And similarly, Yurov and the Komachini case were front and central to the argument. And so it is a very strange thing indeed that the judge didn't deal with it in his judgment in the context of repayment, and brushes it aside in the consequentials judgment. But in terms of what this court can do, your lordships will have obviously seen the material, and it is limited material at the end of the day. And the critical point in Mr. Beketov's evidence is the point I started with this afternoon. Mr. Beketov, as I've explained, accepted where you have a valid loan, but which is repaid or you take our facts. If the relevant loans were valid, then a repayment via a drawdown or a misappropriation, something taken from the bank's own resources, his evidence was completely effective, both to repay the loan and to extinguish the tort. And so the question is, and I posed it, I think, rhetorically, and we didn't actually hear any answer from a learned friend, is what is the difference between a valid loan and a void loan in terms of the effect of a repayment? Now, there is a difference, which is where you have a liability and restitution. If there's more than one liability, the recipient can appropriate the payment to a different restitutionary liability. But if he hasn't done that, and he's actually appropriated it to the restitutionary liability that the borrower has selected, you are then in a position where it is very difficult to see why the position in Ukrainian law would be any different to that which applies where you have a valid loan. And the principles of full compensation, fairness, or real benefit in the case of the valid loan don't apply to the bank's claim. So we say, why is a void loan different? And as a matter of principle, it's difficult to see. And the reason I took you through the detail of Mr. Beketov's evidence is that you can see how things developed from his putting forward this very general proposition which would apply across the board in his reports, and that was the basis on which my learned friend defeated me in the Court of Appeal at jurisdiction, which was on the basis of this general proposition. The cross-examination showed that that general proposition wasn't right, and that what one found in the course of his cross-examination, Mr. Beketov came up with, in a particular circumstance only, and that's the important thing, where you're dealing with restitution, that it would make all the difference that the repayment was ultimately sourced from the bank itself. Now, we say that the judge shouldn't have accepted that as representing Ukrainian law because it was not based on. I mean, my learned friend, my Lord Justice Henderson says, well, it's unfair to talk about ipse dixit in a situation where there isn't any authority and people are expressing their opinions. Now, that's right. That's right in one sense, in that if you have an issue of foreign law, and very often it may be uncharted territory, then somebody's going to assist the court. But what they're ultimately saying is they're giving their opinion, but if it can just be, well, an assertion of that's what I say the position is. Now, you might say, well, they are informed, but in our case, even if one says it's unfair to call it just ipse dixit, this is something where the expert is giving the benefit of his experience and so on, you have to look at it in the context of what else he was saying about valid loans and the analogous situation. And we say when you look at it there, and then you can consider the Yurov case, and if I can just say something about that, my learned friend says that Mr. Beketov wasn't accepting the validity of Yurov and Komarchini for the benefit in the context of the repayment defence, and he was only looking at it for the purposes of use of funds. Now, that's actually not right, because he looks at what he said was he was looking at Yurov, all the relevant paragraphs that I showed you of Yurov. But more importantly is, and this is the point that I showed you Mr. Alyoshin said, you can't look at Yurov and say, I agree with it in respect of use of funds, but I don't agree with it in respect of repayment, because its analysis as to why the use of funds defence doesn't work is because the repayment defence works. And that's the whole point of it. And so that is, we would suggest, a serious and major flaw in both Mr. Beketov's approach and the learned judges, that it's a failure to grapple with what Yurov was saying. Now, when my learned friend was dealing with what in his written argument he calls appeal ground 2, he took you to the learned judge at paragraphs 1115 to 118. Now, these paragraphs, in terms of, he says, what he was seeking to say was that the learned judge was quite right to find that the bank had not accepted the payments, had not chosen at any stage to treat the payments from the new loans and the intermediary loans as discharging the relevant loans. Now, if you actually look at this, this is actually a very interesting part of the judgment. It starts at, my learned friend rather skipped over this. So if you go to page 404 of the judgment, which is the facts on which the defendants rely to establish the bank's choice. And at 1098, the judge says that he's going to say why the factual allegation that the bank made the choice is not established on the evidence, and the reason why it's not open to Mr. Kolomoisky to pursue the point in the manner he has. And he then says at 1099, he refers to the fact that we said the consciously decided to treat the new loans as valid and outstanding, and the loans to the 193 borrowers as having been repaid. We relied on evidence relating to banks' post-nationalisation conduct and the banks and the knowledge of the new management of the loan recycling scheme and the misappropriation. So he then referred to various bits of evidence that we relied on, and that goes through, and we still rely on this, to go through to 1106, where he recorded that we submitted that armed with this knowledge, the bank made a decision to treat the new loans as creating liabilities which were outstanding but impaired, and the 193 borrowers as discharged, and so on. Now, then at 1108, you see that he says there was no proper analysis of how it was said that the bank's 2016 statements evidenced an irrevocable free choice to treat obligations arising in relation to the relevant loans as wholly discharged, let alone to extinguish the tort claims. Now, there are two things in that sentence. The question of whether they had treated the obligations arising in relation to the relevant loans as wholly discharged. As I said earlier today, they undoubtedly had. And the question of whether it needed to be an irrevocable choice simply didn't arise because the bank had at no time sought to revoke that choice. But the judge then introduces this further concept, and this is what you then see in the paragraphs that follow, about a choice to extinguish the tort claims. And that, you see, he comes back to at 1115. And you can see what the bank's case was. So he says at 1115, there was no challenge to the general description given by the defendants of the information available to the bank's new management at and shortly after nationalisation. So just stopping there for a moment, it's accepted that at nationalisation, the bank, the new management, knew everything about the relevant loans. They knew what had happened. They knew about the assets. But the bank's submission was this. However, the bank did challenge the defendant's submission, but the steps which were taken by the bank with the benefit of that information amounted to any form of free choice election to treat the claims it had against the defendants as extinguished, or to choose a claim against the new borrowers as its sole remedy for compensation for the harm it suffered as a result of the defendant's unlawful acts. Now, what you can see there is the bank was setting up a different case to say that we had to, the judge's treat said they were challenging our submission that essentially they had waived the tort, when we were making no such submission. I made that clear to the judge. Our case was and is a much simpler case, that the bank had received the payments and had treated that as repayment of the relevant borrower's liabilities. And you see that's and you see this again at 1117, where in the second sentence, all the events relied on by the defendants were simply short-term attempts to make recovery from the new borrowers. This is suing the new borrowers, and nothing came close to manifesting an election or an unequivocal decision to waive claims. Now, again, that's all setting up a straw man to knock down, although the judge at 1118 then largely takes the same point, because he says in the last sentence, however, whatever the legal principles to be applied to establish irrevocable choice or consent, I'm satisfied that nothing by the bank came anywhere near establishing that. And in our submission, what you have to do is recognize that it wasn't our case, and it's not a necessary part of our case that there was waiver of the tort. Our case is that the bank has received payment in respect of the relevant loans via the intermediate loans and the new loans, and it has at all times since receipt of that money, including post-nationalisation, treated the relevant loans as discharged, and similarly, in respect of the asset transfers, it has credited the relevant borrowers with the value that it has ascribed to the assets, and that remains the position to this day. So, now I think I've obviously I don't need to repeat other points I've made, and I'm conscious I've probably repeated
We
already.
have a note and we have a transcript.
Yeah, but my lords, unless there's anything else I can assist you with, we invite you to allow the appeal.
Very good, thank you. Well, counsel are to be congratulated on completing their arguments within 2 days, half a day short of the estimate. We will be reserving our judgments, and as I'm sure you're all aware, the procedure will be that you will get a draft in due course under embargo, which is to be strictly observed for the purposes of correcting typographical errors, mistakes as to dates and things of that nature, not for the purpose of re-arguing the case. And secondly, for the purpose of seeing if you can agree a consequential order, which we hope you can do. If you can't agree a consequential order, then please make brief written submissions, and we will decide the points of dispute on paper, and the final judgment will be handed down electronically with no further attendance required. Thank you again.
But Lord, can I just say, I said in the course of my submissions that there were some additional pages of my oral closing
Yes,
submission.
if
I
you
want to show you.
could send the relevant pages to our clerks, that would be
Yeah, I'm
appreciated.
grateful. Thank you, my lord.
All right,